Parker to explain. There's actually two parts to this bill that we sort of consolidated from two bills into just one bill. So Senator Parker has a portion of the bill, and then Senator Sparks has the other portion of the bill. So we're going to recognize Senator Parker and any guests you might like to recognize here today.
Absolutely. And thank you, Mr. Chairman, for allowing me to attend this morning too and being part of
Sorry about that.
some of the interesting debate. Actually, I did enjoy it. But we have one bill here. This is you have in front of you a committee substitute for Senate Bill 2572. This bill does three things. I'm going to explain two of those, and then I'm going to turn the third explanation over to Senator Sparks. The first thing it does is something we passed last year. As you're aware, in one of the bills, we added a fourth offense DUI a few years ago, and for reporting, people from Mississippi are being prosecuted for fourth offense DUIs, but we did not change the out-of-state provisions to recognize an offense out of the state. So someone in my area who might have two offenses in Tennessee and then have two more in Mississippi are just being prosecuted for two offenses instead of the four. So this would fix that. This was passed through the Senate committees last year. Got tied up in a conference report that did not make it to the final product. That is on line 215 for that portion. The second portion I'm going to explain came to me from the AG's office. This has to do with our federal highway funds. I received some letters from our U.S. senators and from the U.S. Department of Transportation concerning this issue, and they've been doing thorough reviews of state statutes for compliance with the federal funding money that comes to the state. They have found a particular issue that I'll explain that says that is clarified in this bill, and this would allow that all expunctions for DUI offenses, including any granted by an intervention court, must be granted in compliance with the DUI section of our statute. This limits such expunctions to one on a first offense under certain circumstances and requires the expunction to be included within the DPS confidential registry used to prevent multiple expunctions. So what the federal government is basically saying is they're trying to prevent a situation where someone could kind of get away with something a couple of times and not have any record of it be on file. So this in the bill would create a confidential registry, which would just make note of that. The cost to the state, if we do not comply with this, is $12 million a year in federal funds, and I will be glad to share with any members of the committee the letters from the AG's office, letters from the U.S. Department of Transportation, letters from our Senate colleagues in Washington on the importance of this issue. But that comes up in lines 356, 462, and 490. And just because we're on that issue now, we do have representatives here today from the AG's office. If they would like to add any comments at this time, I would be glad for those comments, or or you're welcome to answer any questions members might have. Molly, do you have anything to add?
Any questions? I'm Molly Miller, Special Assistant Attorney General. So if there's any questions in regards to this, I'm also got Judy Martin here as a Special Assistant Attorney General for MDOT.
Thank y'all. Welcome.
Just to clarify on the registry, it already is. This was just saying that you have one pathway. Clarifying the statute that it is the one pathway under the DUI statute, and it does have to be reported as the DUI statute. It's not, you wouldn't create any additional.
So it's not new, it's just clarification.
Yes, sir.
Yeah. And thank you for that explanation.
All right. Any questions on this portion of the bill for Chairman Parker?
Then Senator Spark.
Senator Hill.
Senator Parker and I have discussed this before, and I think what he's moving toward is the right thing. What my concern is like when somebody winds up with a DUI somewhere, and if the court knew or the judge knew that this was their fourth or fifth offense or whatever, they might not grant bail. I had one of those things happen in my area where a young lady was killed on the interstate, and that person had just been granted bail in another state. So I don't know how we address that, but the fact that they can't in real time right now, when they arrest somebody, be able to look and know how many offenses they've had because they've not entered in. I think you're moving in the right direction. I'm hoping that this will solve it, but I don't know if it will in that time frame.
I think previously we've passed bills to try to, I think the goal is to get a uniform database where we have real-time reporting on this. And I know in the past few years, we've made some strides towards that. I don't think we're there yet. I'm open to any new suggestions to try to improve that, but I'll go back to what started my passion on DUI was Melandis Benson, who unfortunately killed 2 young students from Briarcrest, Maddie Cruzy and Rachel Lynch. And I told the people involved in that situation that I would continue to keep a strong eye on DUI as long as I continued to serve in the Senate.
The only thing I could maybe suggest as we go through this is to make some provision in there to require a judge to check that database to see how many DUIs that person's had before they grant bail. I don't know if we can.
We have a response from Molly, if you want to share.
Yes.
Senator, so what the law requires right now is when a person gets arrested for DUI, the officer by statute is responsible for checking 3 things: their driver's license history, running NCIC, and also checking DPS's confidential registry. Any information that they find out, they have to give that to their prosecutor. It's called certification. That would hopefully catch it. Now, the problem is that all of this information, if it's not been entered into NCIC, or if it's not showing up on the driver's license history, then that can be one of the issues why you see somebody being charged maybe with the first offense when it should be a second, or it should be a third, or it should be a fourth. That's what's on the books right now.
Okay, thank you.
And to that point too, Senator Hill, I know I worked with Molly in the past about making sure our clerks had a little more persuasion to try to make that move in an expedient manner. And I do believe that it has helped the situation. But I hope in the next few years we'll have a look back on that. And I've also had conversations on, how many people are actually being prosecuted for beyond a first offense. I know when we first started looking at this, there were very few prosecutions beyond a first offense. And after this has been in place a little bit of time, I look forward to seeing some data on really what's happening in our court systems, and if we have made a difference or if we need to retool a little bit more. But for the second part of the bill, Mr. Chairman, Senator Sparks and I worked together to try to include some language from his bill that I'm in favor of, and that I think can recognize another situation that will help some people who in a particular situation. So Senator Sparks, if you would.
You're recognized, Senator Sparks.
Thank you, Mr. Chairman, and thank you, Chairman Parker. On lines 329, what we're addressing is the ability of an individual to have an expungement of a first offense, a true first offense, only charge you've ever had in relation to it. What we had when the law came into effect in 2014, with a non-adjudication, you could get a non-adjudication, but not if you refused the intoxilizer test at the jail. You could have taken every roadside test, portable breath test, but if you refused the intoxilizer test at the jail, you were deemed a refusal and not eligible for non-adjudication. The legislature then fixed that to allow non-adjudications on true first offenses, but the problem was there was no expungibility if you refused the test for any period of time. So if you had a conviction, when I believe in 2014, when the non-adjudication law came in, we allowed for an expungement of a true first offense after 5 years of the completion of all parts of the sentence. That was an exclusion if you refused the test or you blew over a specified limit. With this amendment to the bill, with this change in the law, a person who refused or did not blow under that arbitrary limit could apply for expungement 10 years following the completion of their sentence. And I think we'll eventually age out of this issue because of non-adjudication being available to first-time offenders. But this would help with people who had a DUI in the 70s, 80s, 90s, 2000s, early 2010s, to have equity in the fact that that's the only violation they've ever had of the DUI statute, that after 10 years they could apply, and that's all it does.
All right, questions of Senator Sparks on this portion of the bill? Senator DeBar?
Thank you, Mr. Chairman. Senator Sparks, in this section, you're on line 335, we're talking 10 years after basically they come off paper. Is it 5 years on a normal expungement statute?
It is 5 years. Of course, law enforcement would prefer you take the Intoxilizer 8000 test at the jail. And so I think that was why the exclusion from even having a chance of expungement was there. So under this situation, it is 10 years, which still encourages someone to say, look, you know, if you don't take the test, there's an additional penalty. But primarily, these are going to be pre-2014 DUIs, 2015 DUIs. But it's really difficult to look at somebody who's had only an offense one time in the 1990s, and it's still out there because you could not expunge it when we allow expungement of felonies after 5 years. So it's
I guess my question is, if our expungement statute allows for a person to submit a petition for expungement after 5 years, why are we doing 10 years in this statute? What's the difference? Why is that?
Well, the only difference would be that this is a case where someone has refused or they've blown over a limit that is covered under the current law. Now, I certainly would accept 5 years, but I spoke, with Senator Parker in conversations, this was kind of a reasonable guideline. And again, I think the bulk of these are going to be pre-2015.
Senator Simmons?
Thank you, Mr. Chairman. I actually was going to make an amendment in light of Senator Barr's concerns, because under our current expungement laws, we actually allow felonies. And so Senator Sparks, I guess you can understand, we allow people to petition the court after 5 years for felonies, and a DUI is not a felony. So my amendment would be to amend line 335 to say 5 years as opposed to 10 years. And I hope I can get the committee support on that.
Would you like to reply to that, Senator Sparks?
I would, and I don't have an objection to, and I understand the logic, but I would say if you're going to offer that amendment, that I would suggest you just simply strike the language in the 5 year portion, and I'd leave that to drafting, because there would be no reason to repeat the same information. Because if you look in starting on line 306, it's the exact same language that says 5 years. Who successfully completed all the terms, that remains the same on 316, 317, 318, and 319.
I agree.
If you refuse that. So in other words, I'm not trying to tell you how to make your amendment, but if that's the spirit of what you want to accomplish, striking 318 and 319 and 320 through 322 would actually accomplish the same thing. So I'll leave that to the will of the body as far as your amendment.
I agree if some of the bar agrees. Okay, I agree.
I think Senator Parker had a question, maybe.
Well, my question would be a comment on this is, this was a collaborative bill to try to find mutual kind of compromise, because just in general, the work I've done on DUI over time has in general been to make that law much more strong and much more punitive over time. But in the spirit of compromise on this bill, what I allowed to come into the bill was some statute to recognize the unique situation over an extraordinary amount of time to be added to the bill. And so if the intent is to make that change, my intent would be to add another amendment after that amendment to strike the portion of the bill that includes Senator Sparks' language and to allow it to proceed to fix the highway issue instead. Because I had the research done on 10 years. I looked into it to make sure we were not going to, in that situation, be in conflict and create a problem where we're back next year trying to figure the remedy for the highway funds being changed. And to make that amendment right now basically changes my entire feeling on the bill.
All right, you've heard from Senator Parker, Senator DeBar.
In light of Senator Parker's statement, can we ask the AG that if we change the 10 years to 5 years, if that would jeopardize federal funds?
We can certainly ask them if they have a thought on it.
I can't speak right now as far as what is or what or would not do. I know that as long as it's a first offense, the issues with NHTSA seem to be more with multiple DUIs, making sure that they are not expunged. This would still be a first offense. But Judy may have more to say on that.
Yes, sir. So when you're talking about this, you're talking about section 164 violations, which are primarily concerned with two things. One being a 5-year look back period. So
If you guys could speak into the microphone, we have people watching, on Zoom that can't hear us. I'm sorry.
Thank you.
Yeah, you can just take it out and hold it.
Thank you. So the issue on 164 is, one, do you have, it's about repeat DUI offenders. So how can you properly identify those offenders? Can you look back in the last 5 years? That's a federal regulation called the 5-year look back period. So I do believe the original statute did comply with that as written. The other issue would be, are you imposing the proper mandatory minimum sanctions and restrictions? And I don't believe this one would affect that. And that would be my interpretation of the federal regulations. However, of course, NHTSA would be the final
Right.
decision maker on
And
that.
I know we just put you on the spot, so I appreciate your help.
Thank you. All right. Who else? I think I saw somebody else had a hand raised, maybe? Anybody? All right. So you've heard the amendment. We're back to the author of the amendment. Senator Simmons, if you'd like to close on your amendment.
Yeah, and I'd just like to say, Mr. Chairman and members of the committee, we basically are reverting to existing law. And like you just said, we are not changing the existing law. It's already in the existing law. And it sounds like it's already been okay with NHTSA. And we are certainly not talking about multiple DUIs. We're only talking about just the first DUI. So I ask for support on the amendment.
All right. You've heard Senator Simmons' amendment. All in favor say aye. Any opposed, nay. I believe the ayes have it. The ayes have it. All right. Any other questions, comments, amendments, anything? All right. So you've heard an explanation of both pieces of the bill. We now need Senator Sparks for a motion.
Motion.
You've heard the motion. All in favor say aye. Any opposed, nay. The ayes have it. Thank you. And motion to rise and report. All right. You made it. Thank you.